All right, welcome back. Our next session here is called Global Incident Response, Managing Incidents Impacting Global Enterprises. It's a really interesting topic. Our first guest I want to introduce is Robert Maddox of Devois and Plimpton. He's a member of the firm's White Collar and Regulatory Defense group, as well as the firm's data strategy and security practice. Robert's practice focuses on cybersecurity incident preparation and response, data protection and strategy, internal investigations, compliance reviews, and regulatory defense. Robert is in the London office. Welcome, Robert.
Hi, Bruce. Nice to see you.
Very pleased to welcome Jackie O'Hagan. She is managing partner of Accelerate Procurement, also based in London. Jackie has over 25 years experience in procurement and consultancy, working for FTSE 100 companies across a broad range of industries. Just practical experience in many of the planning and the partner vendor management issues that come up with global breaches. So she's a great addition to this panel. Welcome, Jackie.
Hi, thanks, Bruce.
Next, I'm very pleased to welcome David White, Managing Director and Global Breach Notification Leader of Kroll's Identity Theft and Breach Notification Practice. He too is based in London. David began his career in the British Army, where he headed the branch responsible for providing geographic and data intelligence and advice to UK Special Forces and other government departments. He has over 20 years of experience helping clients resolve complex data-related issues, and his engagements include the most high-profile data breach on record, which affected nearly 500 million consumers worldwide. So welcome, David.
Thanks for having me, Bruce.
Finally, our moderator today is Mark Young, partner at Covington & Burling, who advises clients on data protection, cybersecurity, and intellectual property matters. He has particular expertise and focus on EMEA cybersecurity matters and a deep experience in the information technology field. He's actually previously an IT consultant at PwC in his past life. Very pleased to welcome Mark. Will you please take it away?
Thanks, Bruce. That's terrific. Well, look, we thought we'd get started just by doing a bit of scene setting before telling you what we're going to cover. Since last year, we've seen a continued uptick in new cyber laws. In Europe, many of you will be aware that NIS2 was recently agreed, imposing more detailed technical, operational and organizational security measures and governance requirements. Slightly different reporting requirements for certain incidents. Just to mix things up, there's a cadence of 24 hours for an initial breach, a 72-hour update, and a 1-month final report. And also impacting sectors like medical device manufacturers, food manufacturers, and others that may not be as familiar with security-related laws and incident reporting requirements compared to some other sectors. In Europe, we've also seen the Cyber Resilience Act published just last week, developments underway in the UK in parallel. And then on the other side of the pond in the US, we've seen cyber incident reporting for critical infrastructure legislation, rules, SEC proposed cyber reporting rules, specific rules for the financial services industry. The invasion of Ukraine led to the CISA Shields Up advisories. And then over in China, we've seen just a deluge of laws and regulations, including regulation of important data, national security, new transfer restrictions. And that's just in the cyber security space, which a few years ago had very few specific cybersecurity rules and laws. In parallel, we've seen this continued uptick in new data privacy laws and data breach notification rules. And examples include Russia, Saudi Arabia, Bahrain, Thailand. And we've got reviews ongoing from Argentina to Australia and various bills and proposals in South America. So today, we're going to touch on a range of issues that come up when managing incidents impacting global enterprises and hopefully provide some practical tips along the way. We'll aim to cover the impact of some of these new requirements on response practices and partner vendor management. Some trends and tips on coordinating notifications. Working with affiliates can be a tricky issue that comes up in practice. We'll hope to touch on practical points on notifications, maybe credit monitoring as well. Issues around speaking with law enforcement and agencies, and some recent regulatory and industry developments, including insurance coverage, if we have time. So that's a lot. We've got 45 minutes. We'll dive straight in. I mentioned some of these new requirements and companies that are directly in scope of some of them have their work cut out, but there can be an indirect impact as well, thinking about contracting and the like. And maybe, Robert, you could touch on that, and David, if you want to chip in on this one as well, how companies need to be thinking about this.
Sure, thanks, Mark. So I think an opening point on this would be, obviously, look, we're talking at the Incident Response Forum, so some people might be thinking, okay, why are we talking about preparedness? And I think really, I'd just say, incident preparedness and incident response they're just inextricably linked. Preparedness is so key to having an effective response if and when you're subject to an incident. And traditionally, I think we've probably seen a lot of focus on policies and procedures. All of us here have spoken about incident response plans, tabletop exercises, playbooks, and the like, and those are all very important. But one area that I think has received, in some sectors at least, perhaps less focus historically, is when you're contracting with third parties, and I don't mean your incident response service providers, I mean your day-to-day third parties that help you operate your business. What are you doing there that is going to allow you to respond effectively to incidents, both from a practical standpoint, giving you the information and the support that you need, but also, given everything you said, Mark, contracting in a way that's going to meet the expectations under some of the forthcoming regulations and laws around the world. DORA, the EU Digital Operational Resilience Act, is going to change for many financial services organisations how they look at their vendor management. I don't think it's a huge change versus best practice. There are a few areas where some of these laws are a bit quirky, but overall, I think actually what we're seeing is a codification of what I would hope as an outside advisor companies would be wanting to achieve already. So some of the areas that I think are particularly important, and actually I think if you focused on just one area at all in the contracting space, is your audit rights. We'll all have seen GDPR-driven audit rights. They can be a little bit light, and there's been an evolution following the European Commission standard contractual clauses for data processing agreements, which give a little bit more flesh to those audit rights. But I still don't think we're quite there in terms of the level of sophistication and granularity and audit rights that you would want. And I think with the pressure coming from DORA and other new regulatory regimes, I think that audit rights area in particular is going to be one that if I was advising a client, I'd say let's focus there and go from there, because we've already seen regulators pushing on that. Okay, have you flowed down the contractual provisions to your fourth parties? Prove it. If you don't have a robust audit right that gives you the right to get access to that fourth party contract, you're really going to struggle to prove it.
Yeah, it's an interesting point, and it kind of plays into this broader issue around contracting and procurement challenges. It's something that inevitably comes up during incidents. But Jackie and David, perhaps we could just start by touching on some of the planning considerations, perhaps, both on the proactive and reactive side that you're seeing.
Yeah, thanks there, Mark. I'll make a start. Procurement really do have an important role to play, both in terms of making sure that partners that you may need to engage, external partners to support you through an incident, are already in place, but also that the response plan is fully operationalized. And Robert, I know you mentioned a lot of global enterprises now have got their plans in place, their incident response plans. I still see a mix of that. So certainly a lot more prevention strategies are firmly in place. But still, I'm aware of organisations that are having to now react to an incident and there is not a plan in place. And certainly organisations like Kroll are fully equipped with their breadth and depth of experience to advise as you go. But certainly my opinion would be to make sure you do have a plan in place that really addresses how you as an organisation will seek to respond. And I mention that because something as simple as just team mobilisation, who is the internal team that will be privy to managing this response? And actually, do they have the capabilities? And if not, have you already upfront identified those external partners, be it law firms, be it PR and comms organisations, or actually negotiating organisations, or those set up to deal with any notifications? Are they already in place? Because again, you want to be able to immediately invoke those partners coming on board. But also a big learning for me has been you really need to work with those partners that can adapt and flex, because these scenarios change as they get underway and perhaps new jurisdictions become involved. You've really got to make sure you've got the right partners with you that can flex as needed. And I think as importantly is, what's the scope in that your organisation will really adopt? So is it always going to be a globally led response? Because sometimes these data breaches can be very localized and then they scale to become more global, in which case you need to make sure there's really clear decision-making governance in place between global and local, but both are equally important in terms of how you're going to manage that response. There's other more practical things like, if it's a PII breach, do you at some point want your own captive shared service call centres involved? Could also be something that you think about. What's your organisational positioning? And we will come on to this if we get time, on credit monitoring and where and when you will offer that, and perhaps also ID monitoring as well. And there's a requirement in those countries impacted around those two types of monitoring, but what's your organisational response to that? So they're just a few of the pieces that I would see having ready in terms of scope, but also commercially, really important topic, really for budget provisioning, but also just to think about how do you allocate potential cost implication to various types of breaches. It's really important that you're not learning as you go how to engage specialist support organisations, and that indeed you've created a model that you can play scenarios through to understand how that will operate and what the potential cost could be. I think the fourth thing then to me, which is really important, is treat these response plans like you would your BCP or your DR planning. So these should be stress tested annually. They should be updated with what other cyber type attacks have been seen across different organisations, and make sure they stay relevant, updated and stress tested. So they're just some of the pieces I've seen as really important in that space.
I'd agree, Jackie, and sort of going back to Robert's point when you were talking about those audits and those trickle down terms. As somebody that works as clearly a vendor in this space, part of our services are authorised and regulated by the FCA, and one of the things that we have to do when we contract our vendors is, as you say, make sure that the audit rights or the requirements on us as a regulated body, we have exactly the same terms and exactly the same ability to get that information in the event of something going wrong, so that actually we can provide those notifications back to the regulator, whether it's the FCA or the ICO in particular in the UK, as quickly as possible. And what we don't want is for us to then hit that brick wall of, well, hold on, you need to share that information for us. I think, what we're seeing now is in all of our contracts, both with us as the client, but with also us as the vendor, we're seeing much more of those trickle down terms, so that actually the pass through of data or the pass through of information can be as quick as possible. And I'd echo what you were saying, Robert. Part of this shouldn't be anything new. It's all about best practice, but some of this now is definitely coming much more to the forefront. And Jackie, I think you're right about a lot of this in terms of the planning and preparedness. I often get asked to come in and help out with tabletop exercises. And one of the first things we kind of talk about, and some of these things are relatively basic, but it's all about who internally needs to be involved. And it's making sure you've got the right number, and that's not too few people, but also not too many people. And then who are the decision makers? And I think that can be. It sounds really quite simple, but in practice, having been somebody who's worked alongside a number of clients who have experienced some of these data security incidents, sometimes the delays can come not because we've reached the pragmatic solution, we know what we want to do, but it's just that initial sign off on how we're actually going to proceed. And I think, Jackie, your point about going forward from the point of incident, you may have that the global DPO may be the decision maker on this, but you're absolutely right. When it actually comes to the actual nuts and bolts of the potential response, in whichever way that looks, certain jurisdictions actually may decide to do something different. And we know, especially in Europe, certain jurisdictions like to or have to be much more involved. We know certain jurisdictions also have different regulatory responsibilities about how they may respond to some sort of data security incident, and also things that may be absolutely normal in the US or the UK may well be actually certainly illegal in certain other countries.
That's an interesting point, David. I've seen that from time to time about certain activities requiring local licenses, for example, and this issue coming up. But I just wonder if there was anything more that either of you would like to say about engaging specialist vendors or issues that you've seen come up around where data in connection with incidents needs to be stored or whatever it may well be.
Yeah, I can start with that. So I think one of the things that we definitely see as a vendor is sometimes fairly strict requirements about where that data is going to be stored and worked on, and so making sure that we have the provisions to abide by those requirements, but also in a pragmatic sense as well. And so it probably wouldn't be pragmatic to hold, if let's say 100 jurisdictions are impacted, all the information for each jurisdiction in each country. That would slow down the response, where it then may have an impact to the client's regulatory requirement to notify a regulator or consumers. But then having an understanding about what the local laws are and what may have to happen. And I think the other interesting bit that we're definitely seeing a lot more from our perspective, and Jackie, I welcome your thoughts as well, is that not all vendors do everything themselves. Sometimes they have to subcontract parts of that service out. And actually, certain vendors only operate in one jurisdiction, and therefore, the data will have to leave that country. Generally speaking, the country that you're working in. And so, just having an understanding about it may not be always possible to keep the data all in one country. from that perspective. And I think we're definitely seeing this a lot more with in terms of the language capabilities there, to making sure that everything is being done in very specific languages for that jurisdiction. But again, that creates exactly the same sort of more pragmatic solutions to what I was just saying.
Mm-hmm.
Yeah, and David, I think many of those points for me really come down to procurement's role, again, with various functions across the enterprise, really understanding the suppliers they're engaging with and their supply chain, and therefore where data sits, where responsibility sits. Has the trickle down effect gone through that supply chain as well? And I think the more awareness of those really strategic partnerships across multiple suppliers, you can almost wrap a very specific cyber mesh around that, where you understand where data is being held and transferred and where the vulnerabilities are, such that they're being managed in that way. And I still don't think we're quite there yet. It's a huge investment for organisations to have to really understand those true processes, linkages and vulnerabilities, and where data is being held and managed. So I think it has to be a long-term journey, certainly not a quick fix.
Well, look, let's shift gears slightly, because it goes to show the complexity of preparing and getting in place all the different pieces and specialists, whether it's not just PR firms that are specialized in crisis, but cyber crises specifically, or otherwise. But let's shift to you've got an incident, you're having to coordinate notifications, and one of the earlier panels explored some of the challenges just within the EU on this and GDPR related notifications. But Robert, I think we're both seeing an increasing need to work with local counsel due to uptick in the local mandatory requirements, many of which have short deadlines. Many of the laws apply extraterritorially. I might just invite you to provide some examples or color around that and what people need to be thinking about.
Sure. This is me saying all this with not wanting to sound like a broken record, because we probably touched on it a bit last year. But the reason it's worth touching on again is just because, gosh, every few months it changes. And actually, I'd have to say one practical tip that I just want to flag up front is, if you've dealt with an incident 6 months ago, don't just assume that the regime that you're having to deal with 6 months later is going to be exactly the same, because sometimes it's just not. And the pace of change isn't slowing down. And some of these new regimes are, at least on their face, until we've got more regulatory guidance, more on the ground experience of them, look extremely onerous. I mean, in Japan, the notification regime there that's relatively recently come into force, an extremely low threshold for notification, such that you might be sat there scratching your head and thinking, what isn't notifiable here? So it's forcing organizations, I think, to think long and hard about whether the law applies to them, and if it does it trigger notification in circumstances where maybe they don't actually have that much time to think about it, which is the challenge. And that's where I think, maybe 5 years ago, it was much easier to handle these incidents on a centralized basis in terms of your outside counsel relationships. I think the need for specialized local law advice is greater than ever. But I also think that one of the greatest challenges for those in-house companies dealing with these issues is coordinating with local businesses. It's much harder to run a centralized incident response effort from the sort of the legal and regulatory side now than it used to be, because you've got local lawyers who understandably are perhaps the ones signing off on compliance. It's their name on the registry at the Data Protection Authority. Right. So when you tell them that we're notifying, sometimes you get pushback. Sometimes you actually, you've got to discuss it, and maybe 6 months ago you didn't have to discuss it, and factoring all of that into how are you actually going to tackle these incidents? It requires a little bit of thought. And my one tip on that is really, you've just got to have this continuous dialogue. You don't want someone being caught by surprise when you tell them that, oh, there's been a data breach and it affects Japan. You might have notification obligations. You want to have discussed the fact that those new laws are coming out and
Right.
being prepared.
Well, I think we'll maybe circle back round to affiliates in a second, but I think it's an excellent point, very relevant. Keeping on top of these new developments and some of the details, we learned recently this new regime in Saudi Arabia required a hand-delivered notice by an authorized agent in Riyadh. There's various jurisdictions in Asia Pacific that have very specific rules around signing and notarized power of attorneys and all the rest of it. And to your point, requiring that local engagement. So the tips that we offer would include keeping a running list of who is on point to notify the authority in each jurisdiction. Is it a member of the local team, a member of the central privacy team, local council? Who is it? Who can actually do that? And during the pandemic, with a lot of people leaving organizations and a lot of movement, that really needs to Jackie's point, be kept updated with your planning. Even simple things like keeping an up-to-date list of the entities, I think, locally, that you need to populate the forms. It's so basic that you've got a notification going to 50 jurisdictions. It's a lot of work in 72 hours if those deadlines are applying. And maybe think about completing one notification form for the organization to approve early to the extent they can and get other local council and other jurisdictions to sign off on that. A speaker on a prior panel raised a very good point about the lack of uniformity across these forms, but there are certain core points which are relevant and that can speed things up. Robert, you touched on hand-holding a bit with affiliates, some of whom may not be that familiar with the local law or lack experience in notifying, and this is a question to everybody. Are there any specific challenges that you'd like to raise or look out for affiliates going off, perhaps seeking second opinions on what's going on here?
Yeah, I've seen that happen, Mark. They if you don't have this high level of coordination, it might be, for instance, that a local operating company in a particular jurisdiction has been working with local council on general compliance matters. And you then bring in your cyber incident response local council, you've then got your general compliance council. And let's just say, as we all know, reasonable minds can differ when you're assessing these situations. And then you have the $1 million question of, well, who wins out in this, in those sorts of situations? I do think there's a strategic point though as well, which is for multinationals where perhaps local operating companies are reliant on parents or other group entities for services, etc. And actually the incident occurs elsewhere but still falls within the jurisdiction of a particular regulator. I think there's a little bit of advocacy at play sometimes now that I've seen coming out, which is making clear the basis on which information is provided, i.e. that the local operating company is providing information that was provided to it by its parent operating as a service provider, and trying to put a little bit of an air gap between, say, a regulator in Brazil and a parent company in the UK, such that you are trying to, as I say, segment your potential liability between your different entities. And that, I think, as you're dealing with more regulators, is going to be more important, because you don't want the long arms stretching absolutely everywhere on an incident if you can avoid it.
No, absolutely. Well, thinking about these both strategic and practical points. David, I don't know if there are if you've seen any particular challenges with these global incidents in terms of local language requirements or having to tailor notification exercises, anything that people should be thinking of when trying to anticipate this.
I do. Thanks, Mark. But I'm just going to go back to one of the points Robert was talking about, and
sure.
One of the things that we've also seen here is that sometimes a jurisdiction that gets brought into the incident maybe further down the line, because when further discovery has been made on data, actually sometimes if a decision was made not to take certain steps, they will sometimes look back at other jurisdictions and say, well, hold on, you did this for this country, so we should be doing something here. And also, we've also seen that other jurisdictions may not agree with let's call it their parent or headquartered company in their response and say, well, actually, we do want to do something slightly different because actually, for various reasons, we want to either do something from a reputational standpoint. So definitely see that come in where there's certain differences there. But you're absolutely right on the whole language side of things. Certain countries, and I think we can all sort of make a guess on which certain ones will spring to mind, can be very particular about making sure that notifications are done in their native languages. What we also find is, again, given the spread, especially in these global incidents, we might actually find something where a certain country only has a small proportion of people. And then just from a cost perspective, we would recommend just sending out potentially an English, written English, potentially notification, and maybe have access to an English-speaking call center. But actually, either it's come back from maybe from because it's hit media, or maybe we've also seen it where a regulator has, I don't want to say demanded, but maybe suggested that a better approach would be to resend notifications and also make sure that a call center has the ability to deal with local languages as well.
Yeah, and sorry, go ahead, Jackie.
Sorry, Mark. I was just going to say if I can add to that, because it's been an area close to my heart for some time. I think you're absolutely right. You should always handle with the native speakers or the English call centres where the majority languages allow for that. And then you've always got the option of that translation service as a backup for minority languages in certain countries, which again doesn't feel sometimes like the right service. But to your point, there's a cost point there. But also, I think this is where part of that, what's your response scope? A lot of global organizations do already have multilingual call centers in place where perhaps some of those calls, and I think this is part of in the scope, what's the exception handling situation where perhaps calls could be transferred from a Kroll call center to an enterprises call center where they have a scripted scenario that they can then handle in local language. So certainly I think it's definitely not one size fits all. I think it's what the organisation feels is the right response. But there is a cost to it, but there's also use your own resources where you have them.
Yeah, and I think you sometimes also see this issue play out not just in terms of the language point that you raise, Jackie and David, is with a consumer organization, a desire perhaps to notify all consumers equally, even where they may not have a requirement to do so, perhaps driven from PR or brand perspectives. And then the investigation unearths other facts that require notifications, formal notifications to go to individuals, and have those ones that have previously gone out, do they meet those notifications? Some challenges around that, and just marking the chronology and timing of this. Going back to something that you said at the beginning of the panel, was to do with credit monitoring setup and issues there. That's sometimes a requirement under local rules, or at least an expectation. And I don't know if either you, Jackie, or David would like to speak to that, if you have any insights on the kind of uptake of credit monitoring and things that people should be considering when engaging vendors to provide that.
And David, look, I'm happy to start more generally, but I think you might have some data to back up perhaps some of these thoughts. But I think that's also back to what is your organisation's response and position on providing credit monitoring and, as I say, potentially ID monitoring. And what I've certainly experienced is some of those offerings are more expected and normal in certain jurisdictions like the US than perhaps in a different European country, a Poland or Romania, where they may not be commonplace. And that's where I think, again, and it sort of touches a little bit on Robert's point, it comes back to really understanding your local requirements, what's normal, what isn't normal, but actually where do you perhaps want to offer something that is a little bit different because you feel reputationally that's the right thing to do. So I think it's have your understanding as to what should typically happen in each of your jurisdictions, decide if you want to enhance that. But certainly, David, I think you might well have some data that backs up typically what the uptake is when those types of offerings are made as part of a breach.
Yeah, thanks, Jackie. I think, I always sort of bundle this and talk about these types of monitoring and potentially identity theft restoration as, in reality, it's trying to provide some sort of mitigation to the potential harm on a result of the potential security incident. And you're absolutely right. You look at the US, and different states have different requirements about what is offered under certain circumstances, and given the type of monitoring and the duration of that monitoring. And I think the US is very, very mature in that market. Typically, we would see anywhere between sort of a 0 and 3% take-up rate in the US. And I think that's mainly because of the proliferation of data breaches that is being notified in the US. And therefore, because all of them generally will be offering some sort of monitoring services. But also, let's be honest, there's also a big class action side of thing over there as well, which also offers credit monitoring. So there's a huge amount of these being offered out there, which I think contributes to this, the smaller number of take-up. But when you start moving outside of the US and Canada, the UK and Australia, and Jackie, to your point, not every country has the same level or the same sort of credit monitoring or personal credit monitoring that certain countries do. And a good example would be, I get asked a lot is, can you do credit monitoring in France? And the answer is no. They don't have the same sort of setup that we have in the UK. But if I use the UK and Australia as examples, those numbers can range from very low single digits up to, and we've seen some at the 50, 60% mark, which is a massive difference there. So how, as a company, can you help to plan on this when in reality you don't know? And I think having those conversations up front with potential vendors and asking them, what are they seeing? But when you start to drill down into, okay, what is the population? What's the age group there? What's the industry impacted? What's the data that's been impacted? Is it an employee base group? Because we know, and we've seen that where employee groups have been impacted, the take-up rate can be significantly higher. I think it would be fair to say that most vendors in this space then, with that level of information, can give a much better view on what the take-up rate would be.
That's interesting. The range of stats between jurisdictions. Just finally, before we move topics, Robert, in terms of the notification process, I think we've all been aware for some time about data breaches leading to phishing expeditions, follow-up. Any practical tips or observations, care that organizations should take when completing forms to try to limit that exposure, or how real a risk is that?
I think you've definitely got to be careful here, because sometimes there's a temptation to say everything you know, put it all down on paper. And I just don't think it's helpful, because I don't think it's helpful for either side, because certainly in jurisdictions where you've got short notification periods, the reality is the facts are still emerging, and it's okay to say that. So I think it's well worthwhile thinking about what you say and when you say it. And I think I sometimes try to give people confidence that you don't need to say absolutely everything up front. And it's not that you are being evasive, quite the opposite. It's actually that you want to be accurate. You want to be sure that when you're saying something, you're actually saying the right thing. And as we all know, in cyber incidents, the facts evolve, they change. And I think related to that is just this point that the regulators might want you to share certain facts, but they might not always be entitled to those facts, or at least they might not be entitled to them at the point at which they're asking for them. And if they're getting in the way, ultimately, sometimes you might just need to say that. You might need to say, look, we're more than happy to engage with you on these issues, but we're going to need more time to answer those questions, because at the moment, our priority is on, if it's a disruptive attack, getting our business back online so we can service our consumers, our customers, so that they aren't suffering detriment.
Yeah.
Penetration attack, it's about working out what's gone out the door, so we're sure that we're notifying the right people, so they are able to take steps to protect themselves, because it's out of our hands now. So I think being willing to have that sort of upfront dialogue can also be very powerful as well.
I think that need for accuracy and being careful about what's being said in the forums also extends to the kind of PR and crisis management, where there can be a real pressure in certain jurisdictions, and depending on the nature of the organization, to go out to the market and pin attribution somewhere, which can be a problem further down the line if it turns out to be inaccurate. We only have a couple of minutes left. We had a range of other topics to talk about, so I'm just going to select one of them, which was the trend in relation to insurance coverage and getting coverage. David, would you be kind enough maybe just to say a couple of words on that?
Sure. We work very closely with our insurance partners, and I think what we've seen and what we've discussed over the last year really is there's been a reduction in the number of policies being written over the last year, and that number ranges, but it's somewhere in the region of 30 to 40%, and so that creates some issues there, because actually there are a number of companies now that where they may have had cyber insurance before don't have it today, or they may have a number of steps they need to take in order to then be insured. And I think the interesting point there is just trying to understand what points or what sort of processes people need to put in place in order then to get themselves back to being, let's call it, insurable. I think from what we can sort of see in the industry, that number will start to go up again. I think the book has calmed down, and therefore, as a result, the number of claims have gone down clearly because the number of policies written has reduced. I think we'll see that sort of slowly build back up again. But I think that was quite an interesting sort of stats that we've seen, and the reason why we hear that is because a lot of the insurance companies are saying to companies, look, we can't, based on the book of work you have at the moment and the risk that you hold, we need to see the following things be put in place in order for you to get there. So it's not the end of the world, and it's not saying you're not insurable, but it is sort of saying actually some things need to change in order for you to be written or have the same sort of coverage that you had in previous years.
Thank you, David. It's obviously a maturing area. Well, look, I think that brings us almost to time. Plenty going on in the past 12 months, plenty going on in the next 12 months. For those of you in Europe, look out for national implementations of NIS2 and the rest. Bruce, I see you in the corner. I hand it back over to you.
Thank you, Mark, Jackie, David, Robert. Great job. Really appreciate you all joining us today.